Good afternoon. It's 12 o'clock Eastern Time, Wednesday afternoon. My name is Robert Bly, and I am, as many of you may know, the attorney who works with Trusts Unlimited. Jim George cannot be with us today. Jim has, for some of you, Jim has been somewhat ill lately. He is recovering, but his strength is somewhat reduced, and these calls do take quite a bit of energy away from him. We hope he'll be back next week, and he did want me to tell everybody that he will try to return phone calls tomorrow and Friday. So if you have phone calls, if you place phone calls either to him or to Trusts Unlimited, please bear with us. Occasionally, when Jim can't be with us, it gives us an opportunity maybe to go over some things. Not so much about the currency situation, because I'm the last person to be talking about a currency matter, as I'm not near as versed in the subject as Jim is. And before I forget, Jim's going to want to know this. Give you our disclaimer: Trusts Unlimited does not recommend, sell, or is associated with any marketer of foreign currency, particularly dinars, Iraqi dinars, and other types of foreign currency. If you'll notice our website, we don't share. We aren't sponsored by anybody. We're totally independent. We do not, and nor do we recommend that you purchase or not purchase dinars. What we do is we do prepare a trust package, which is commonly known as our Wyoming trust package, and it is our position that if you own dinars or any other currency and you believe that they will revalue, then you certainly need to have a trust and have those dinars owned in that trust for various reasons. We do not promote that they save taxes or eliminate taxes. We do not give any tax advice, nor do we give any legal advice, only of a general nature. I guess that deals with everything. But we do prepare a package of trust documents. There are typically 10 trust documents in each package, and unless you have an urgent need for all 10, we certainly don't recommend that you print them off and utilize them, because they are not. There is a lot of printing, and if you have all these trusts, and you should go to the bank or something like that to try to set up a checking account, the bank, some banks will want to see this and see all these trusts, and oftentimes they don't know what they're dealing with, and so the knee-jerk reaction with many banks is that there's something wrong with these trusts, so you don't really need them. I've been an attorney for almost 40 years. I focused my practice primarily on estate planning and trust for the better part of the last 30 years. I'm sorry, the last 25 years. And I've had no end of bankers trying to tell my clients that some of the stuff that some of the documents that I recommended they really didn't need. I find that interesting coming from a group of people who primarily are not that sophisticated when it comes to trusts and other things, but for some reason they feel the need to do that. Be that as it may, I'm not going to talk to you about what a trust is or what a trust isn't, other than to tell you that basically a trust is nothing more than a form of ownership. It is a structure. It is a contract. The trust is a contract between the people who set the trust up, who are the settlors, and for the benefit of someone else, and that usually in our case is usually the people that set them up, and those people are called beneficiaries. Unlike living trusts, where you can be the trustee of the trust, in our trusts, because they are asset protection tools, you cannot be the trustee. You can name a friend or a family member to be your trustee, but you cannot be the trustee of your trust. Having said that, let me explain to you why we call them Wyoming trusts. In my experience, I have had occasion to become familiar with not only the laws of the various states, but of several countries, foreign countries. And many years ago, I, and still do, engaged in the creation of what is commonly known as offshore trusts. Offshore trusts sometimes give people an uneasy feeling because they've heard that they're illegal, or you can get in trouble for using them, which is true. You can get in trouble for using them, and depending on the purpose for what you're trying to accomplish, they can be illegal. But as long as you comply with all the laws of the United States that pertain to these trusts, you should have no problem from the Internal Revenue Service or any state government. The offshore trusts enjoyed quite a growth during the 90s as a form of asset protection because of the fear in many people that the laws in the United States were such as they tended to give an unfair advantage to plaintiffs and plaintiffs' attorneys, and more or less, if you had money or property, painted a target on your back. And so many people started using trusts that were cited in foreign countries. And I'm not going to go into all that, but suffice it to say, in the late 90s, beginning with the state of Alaska, many states in the United States started to enact legislation which gave people that set up trusts using their laws with trustees in their states certain protection against claims of creditors. And Alaska, as I said, was the first, and a number of other states have since followed. To date, and I stand corrected, I believe at least 14, maybe more states have enacted legislation that allow for what we call asset protection trusts. In my research and studies, I happen to be reviewing the laws of the state of Wyoming because in my practice I had used Wyoming law to set up LLCs because Wyoming was the first state in the United States to enact legislation to allow LLCs. And so I thought, well, maybe it's worthwhile checking out their laws with respect to trusts. And what I found was that compared to many other states, the laws of the state of Wyoming were very beneficial for purposes of clients wishing not only to protect their assets, but to have a certain measure of privacy. Oftentimes, privacy, the desire for privacy is considered to be equivalent to some surreptitious or illegal purpose, and therefore people who desire privacy must be up to something. So oftentimes the states in the United States that have adopted this type of legislation have been, while they give asset protection, they are also pretty open about being able to obtain information about the trust and what's in it under certain circumstances. Wyoming, fortunately, is not like that. Wyoming has sufficient privacy to protect the privacy of individuals, and now it doesn't keep you from having to report to the Internal Revenue Service. But as far as another person or their attorneys, there's a certain measure of privacy in Wyoming that really you can't obtain unless you do go to a country that has privacy laws. So in reviewing the Wyoming statutes, and given the fact that Trusts Unlimited was dealing with clients or customers in many different states, it was decided, based on my research and my recommendation to the people at Trusts Unlimited, that the trust should be formed under using Wyoming law as the basis and the governing law of the trust. This is not an uncommon situation. Many times, if you buy something by a contract, if you read the fine print, you oftentimes will see that the contract is governed by the laws of another state other than where you are. And in the area of asset protection, it is not or estate planning, it is not unusual to have people of one state having a trust in another state with another, or having a trust with a trustee in another state utilizing the laws of that state. So this is not an unusual situation. But the use of the Wyoming statute enables Trusts Unlimited to basically utilize the laws of one state without any reference to the state where they may be living. Because like I said, our customers come from all 50 states, and in fact we have some in some foreign countries. And so consequently trying to create a trust that would be applicable to all states, particularly states where they don't have asset protection laws, would be very difficult. But basically, a trust is nothing more than an agreement whereby the trust, in the form of the trustee, holds the title to certain property. The property can be real estate, it can be automobiles, it can be stocks and bonds, it can be foreign currency, whatever. And the trust is managed by the trustee under the terms of the trust for the exclusive benefit of the people who are the beneficiaries. And so what happens is that the trustee has what we call in the law the legal title, and the beneficiaries have what we call the equitable title. An example of that would be, or maybe you might understand, would be if you rent a house. You don't own the house. The landlord owns the house, and he has a legal title to the house. But you, because of your contract, you have possession of the house. And so that is, under the law, that is, as long as you pay your rent and everything, that is a legal, you have a legal right to be in possession of the house. The same is true of a trust, except you don't, the beneficiary doesn't necessarily have a contractual obligation to the trustee. Trusts have been used, and I've used them in my estate planning practice. Trusts survive the death of the settlers, and many of you may have heard of something called living trusts. And what living trusts are nothing more than revocable trusts. By revocable, I mean they can be revoked, they can be canceled at any time prior to the death of the person setting the trust up. And when the person dies, then whatever property, whether it be real estate, stocks and bonds, personal property, whatever property is in the trust passes, and there's no, to the successor beneficiaries, and there's no necessity for having a will, which requires you to go to court, that type of thing. With a trust, the family doesn't have to go into court and open up a probate proceeding to get the property because the trust didn't die. And the trust, in a living trust, there's a successor trustee. So when the initial trustee, who's the person that created it, dies, then the person, the successor trustee, automatically takes over and carries out the terms of the trust. Well, our Trust Unlimited trusts operate the same way with a couple exceptions. One, while you can set them up, you cannot be, because of asset protection, you cannot also be the trustee and the beneficiary. Now, if you set up the trust and you make your children the beneficiary, which some people do, then you can be the trustee because you're not the beneficiary. But if you want to, if most of our customers set up the trust with themselves as the beneficiaries, and so in order to achieve the asset protection, there has to be a separate trustee. Trustees are Trust Unlimited trusts are also irrevocable. What that means is that during the life of the original settlers, the trusts are irrevocable. In other words, they cannot be revoked. They can be amended from time to time, and we do that, but they can't be revoked. And on the death of the settlor or the beneficiary, then the trusts pass to whoever they've named as beneficiaries. And by doing that, you avoid the necessity of probate. You pass on your property to other people. One of the reasons that the Trust Unlimited utilizes different trusts is because we have found that actually this idea got from the Kennedy family. Believe it or not, back when Joseph Kennedy, who was the father of Senator Edward Kennedy and President Kennedy, if you're old enough to remember him, was very wealthy, and he did not want he did not want his children to be taken advantage of by others. So he set up a series of trusts in which they were all beneficiaries. And they never actually owned the property, but they had the beneficial use of it. And what he also did was he created different trusts on different things, different buildings, different businesses, different things, even automobiles. And one of the stories that goes around is when Senator Kennedy had his unfortunate accident about 50 years ago. The trust course, he was the beneficiary of a trust that his father set up. It had a spendthrift provision, and it wasn't. It really wasn't any property of his. And the automobile that the senator was driving wasn't owned by him; it was owned by a trust. So the family of the woman who died was basically there was nothing that they could do. Now the Kennedy family did reportedly pay them a certain amount of money in compensation, but they really couldn't do anything from a legal standpoint because Senator Kennedy didn't have an interest in any property that they could have attached. So that's where you get the idea of trust being used for asset protection and that type of thing. And Trust Unlimited, we believe that we have the best package of trusts for this purpose, for not only for financial purposes, for asset protection purposes, and particularly for purposes of owning currency, and presumably that's why many of you are calling. In the business today. So I've been on here about 20 minutes. I don't really want to talk too long, but I'm going to